Starting off, some of the basics. I mean, this is something that we've been talking about for 5 years now. They passed this in January of 2010. You'd think they would have figured it all out by now, and yet the two main pieces of it that people know best, there's the individual mandate that everyone needs to maintain coverage. You can have gaps of up to 3 months, but generally everybody that is what they call lawfully present in the U.S., so that's U.S. citizens, it's also H-2A workers though, need to maintain coverage. So we'll talk about some of the issues specific to H-2As later, but if you have H-2A workers here for say 6 months and they don't have coverage, they will face a penalty when they go to file the next year's tax return because they have violated the individual mandate, regardless of whether you could have only 20 employees, so you're not a large employer, you're not covered by that. They have their own obligation to be covered. They can get coverage through the exchange. If they qualify, people can get coverage through Medicaid, Medicare, or most people get it through their employer. The piece that's probably more interesting to this group is the employer mandate. This applies to quote unquote applicable large employers, generally defined to be 50 or more full-time equivalent employees. We'll talk about that later too, figuring out kind of who is covered, who is not. The pay or play decision was actually pushed back. That should be 1/1/2016. For most employers that are, the law is written as 50. For this 1 year, it was pushed up to 99. If you're a much larger employer, you may already be covered for this year. If you're in that kind of smaller to mid-size, 50 to 99 window, you get an extra year to come into compliance with it. So, sort of good news. Whether you're large or small, there's some parts of the law that are going to apply to you. So if you have 10 people or if you have 1,000 workers, you need to be sending out what they call an exchange notice when you first hire workers. If you had workers that were you've had for a number of years, office staff that you've had for 10 years or something like that, those should have gone out a couple years ago, but just on the possibility that people haven't. But more importantly, for new hires that come in, it's a notice. You can go to the DOL website. They will have a model form, no reason to reinvent the wheel. It tells the worker exactly what they need to know. There are two choices. There's a form for if you do offer coverage and a form for if you don't offer coverage. You just have to give that to each of your workers. And it basically that's all it does. It tells the worker whether they get it or not, and if they are not receiving coverage through the employer, that they can go on to the exchange. I think, does New York State, they run their own, right? You're not on healthcare.gov, right? So for New York State, you go to the state exchange. And then again, for virtually all of this, anything that applies to a US worker is going to apply to an H-2A worker. They're treated as, for most purposes here, as being lawfully present by virtue of their visa. Yep. Absolutely, sure. Now to the interesting part, kind of what's it going to cost? This is sort of the bottom line part of it. If you are an applicable large employer and the law does apply to you, what they euphemistically refer to as the employer shared responsibility payments, sounds a lot nicer. Basically the employer mandate or the tax penalty. It's forced through the tax code, so this is handled by IRS. This is the part of the law that they administer. For not offering coverage at all, if you were meant to, your worker goes to the exchange, gets a tax subsidy, you get a notice back. You're going to get a tax bill in the next year for $2,000 per head after the first 30 for each of those full-time employees. And if they're only here for part of the year, they prorate that, but that's a pretty steep penalty if you have a lot of employees that haven't offered. If you do offer coverage, but it's not affordable to the employee, for each of those for whom it's not affordable, based on the premium that's charged to them. For some people it's affordable, for some people maybe it isn't. It's $3,000 per person for the year for those people, up to the total of what it would be if you didn't offer at all. So there's a lot on the line for getting the decisions wrong here. Step one, figuring out if you're a applicable large employer. If you're not, the rest of this will be a lot more enjoyable than if it turns out that you are. So this is kind of the threshold issue of whether you're a large employer. It's looking to full-time equivalent employees is what they call it. And a lot of these sort of minute rules, they were trying to stay one step ahead of what they thought employers would do to try to get off the hook for doing this. So the rules about combining companies was because they didn't want somebody that had 120 companies to all of a sudden become 3 companies with only 40 employees, things like that. Or to kind of tweak people's hours so that now everybody's only working 29 hours and you hire more people. There's rules in place to address all of the things that employers would have tried to not be covered. It's 50 or more under the statute, but again, for this year, if you have 99 or fewer employees, then the law is not going to apply to you just for this calendar year, for 2015. For next year, it'll probably go back to 50, but we wouldn't be shocked if they continue the 50 to 99 rule. Seasonal employees, the statute defines that as people working less than 120 days in a year. There's IRS guidance that moves that to 180 days. It's something that comes up a lot in ag. If you have H-2As that are here for 9 or 10 months, that's not really helpful. There's a bill moving through Congress right now to put into statute the 180-day rule that would say both that they don't count toward your 50 worker calculation and also that they're not full-time employees for any purposes. So that even if, say, you have 200 full-time employees and then you bring in another 50 seasonal employees for 5 months, if they only use the seasonal definition to look at whether you're large or not, that wouldn't matter because you already have the 200. But for those people that are here seasonally, you wouldn't even have to offer them. They're not on the books at all for full-time purposes. But they brought that out in the last Congress. It didn't go anywhere. They've introduced it in the House, and they're trying to introduce it in the Senate right now. It's called the STARS Act, in case you want to track that and see how that moves through Congress. Full-time is only, as you know, is only 30 hours per week or 130 hours per month. HR 30 was one of the first bills that the House passed this year. They tried to move that up to 40 hours a week, which is potentially helpful, depending on people's schedules. If you have a lot of people that are kind of in that, 30, 35-hour window, most people probably won't, but just something to look at. And then you combine your part-time hours and divide by, for the month, and then divide by 120. And we'll show some examples of how that works to kind of pool them all together and figure out how many full-time people would be doing all of their combined jobs to kind of get to a total number. And then you add those together with your people that are already over 30. For related companies, you have a family has 2 businesses. They have a packing operation that they treat as separate from a growing operation. They have a trucking company that's separate from a dairy, something like that. This follows the tax rules. If they're under common ownership, there's different tests for this of kind of how much is owned. If you have one brother owns one company and another owns another, and they don't own the shares of either one's company, they're going to be treated as separately. It's tax specific, the same way that you'd be treated as a controlled group. For other purposes, you're going to look to that. They're combined together. So if you have a company with 40, a company with 30, and a company with 20, you add those all together, and that tells you whether you're a large employer or not. Another thing that employers might have tried to kind of get around this, say, oh, they're not an employee, they're an independent contractor. I pay them a certain amount, they come work, but they're self-employed, they work for themselves. That's something the DOL has been cracking down on for the last few years, partly for other reasons, but partly as a run-up to the law coming out. They're really going to be aggressive about this. They're going to try to find that they're your employee and not self-employed for these purposes, because if they're self-employed, it's their problem to get their own insurance. If they're an employee, it's going to count toward your total and you're on the hook. Here's an example. So the company has 20 full-time year-round workers. They have 40 part-time workers who do about 90 hours a month. So, they're below the threshold, they're not going to be full-time, and then they don't use any seasonal workers, just to make it easier. You combine all of the hours that the part-time workers work, so that's 40 times 90, 3,600, then you divide that by 120, so that shows that would be 30 full-time equivalent employees, so basically 30 people could do the job that 40 people are doing part of the time. You combine that together, and so now it's 50 employees. So for this year, again, it's 99, so it's not an issue. But for next year, that puts them right at the 50 worker threshold. And so even though they only have 20 full-time workers, they're going to be covered by the law. A wrinkle within that, though, is if they don't offer coverage, they decide, the hell with the ACA, we're not going to do that. The penalty only attaches after the first 30 full-time employees. So since they only have 20, it comes to the same thing. They don't owe any penalties. So, just to show that, there's a lot of wrinkles in figuring out the numbers at the bottom at the end of the day here. Another company. This company has 40 full-time year-round employees. They bring in 100 full-time workers just for a short period from, say, 4th of July through Halloween. So their monthly average, so there's 8 months of the year, say, when they have 40 workers, and there's 4 months of the year when it bumps up to 100. So their average is 60. And that's the way to do the calculation. Because your workforce is going to change over the year, you look at the average. And if your average is 50, that's what triggers it. There may be months where you have 60, months where you have 20. You have to look at the whole year to figure out whether it's a large employer. But because under the seasonal exception in the statute, the total workforce only got above 50 for fewer than for 4 months or less, they're not a large employer. And so even though their average was above that, that brings them back under. You don't have to count those guys that were only here for a little under 4 months. There's this IRS guidance, and this is the STARS Act that will change that. So say you are a large employer, and a lot of people will be. The requirement is just that you offer coverage. The workers don't have to take it, and for what it's worth, a lot of them will not. A lot of H-2A workers will not take coverage. They've had this trouble, trying to unionize H-2A workers, trying to offer them health care in the past. A lot of these guys come here, they want to send as much money as possible home. They're here to work, they're going to get in every hour they can. A lot of farm workers, even US workers, these guys are young, they're never going to get hurt, they're going to live forever, they never ever get sick. I don't need insurance, that's crazy. So you just have to offer it to them. If they say no, that's up to them. Once you've offered it, and ideally, it's going to be documented. There are tax forms that will show that you offered it to them, just to belt and suspenders, to protect yourself. It's always better to have more documents in case DOL or IRS come looking later. If you have a form that says, I offered you coverage on such and such date, within 90 days of when you started working, they check the box, thanks but no thanks, I don't want it. You put that away in their file, you're covered. You've done your job. It needs to be offered to full-time employees. So the example before, where the company that was going to be covered, where they had 20 full-times and 40 part-times, you only have to offer the coverage to the full-time employees. Those other 40 people that are working below that don't need to offer coverage to them. They're off the table. So you're a large employer, but the offer only has to go to the full-times. You need to offer insurance to the dependents of full-time employees for reasons that defy understanding. Dependent does not include spouse, but does include children up to age 26. I'm not sure why I set up that way, but there it is. And then you need to offer affordable coverage, and we'll talk a little bit more about that later, but that goes to the share of the premium that the employee is expected to pick up. Again, you don't have to offer free coverage to them where you are paying Blue Cross or Aetna 100% of the premium. The employee is expected to kick in a certain amount, up to 9.5% of their income. So it makes the accounting a little more difficult, and there's safe harbor ways to kind of figure out what that is, but they are expected to pick up part of that. And then when you have new workers and you're not sure if they're going to be full-time or part-time, there are rules on that to figure out. They call it a measurement period that can be a certain number of months where they work for a while, you kind of watch how many hours they're working, you figure out, it looks like they're going to be part-time, I'm not going to have to offer coverage to them. Or, they've really been putting in 35 hours a week, 40 hours a week, week in, week out, they're going to be full-time. And then the stability period, they call it, is they stay in that status for a certain amount of period after that. So say they come in, you have a 6-month measurement period, they're part-time. They're doing, 20 hours a week the whole time. But then after the 6-month period, all of a sudden they're working 40, 50 hours a week. They're still part-time for a while, and then there'll be another measurement period later. So generally speaking, most workers are going to be full-time, so things like that don't come in. A lot of these come up in the retail setting, but just so that you're aware. Again, it doesn't have to be free, it just has to be something that they can afford. You look at 9.5% of their household income, and again, you're not going to know their whole household income. There's no way you're going to know if somebody's wife is working. There's a farm worker, their wife works somewhere else. You don't know what that is, so you're covered if it's 9.5% of their Box 1 income on their W-2. If they're first starting out, you don't necessarily know what they're going to be making because, again, you don't know how many hours they're going to be working. So you can take their rate of pay and then just multiply that, assume 130 hours. That's another way to do it. Or the absolute rock bottom is the federal poverty level. If they take 9.5% of that, which this year is going to be, I think it's about $97 would be 9.5% of that. If the worker is paying no more than that, you're definitely covered. Even if their income would allow them to pay more, if you do it safely there, you're always going to be okay. And again, dependent care, the employee is 100% responsible for. You only have to make it affordable for the least expensive coverage that you offer for individuals only. So you can have multiple plans, they have a whole spectrum, but if you have kind of a bronze, bottom of the barrel, that's the cheapest plan that meets all the requirements, and they pay their affordable share of that, that's fine. And then if they have 17 kids, they pay 100% of that cost, that's on them, just to keep it, There's the definition of adequate coverage. This is all in the rules. The health insurance companies will know what this is. Basically if they're offering something and they market it as a bronze plan, you're going to be okay. That's going to meet the minimum value requirement. It just basically means that about 60% or more of their costs are covered. It goes up. There's a silver plan, gold plan, et cetera. Be careful. Some brokers are selling what they call MEC, or minimum essential coverage, or something called a skinny plan. Some of these are not minimum value plans. There's a glitch in the calculator, never believe this, on the federal website. And but so they would be able to list them as that. They've put out guidance recently that said, no. Those are not okay. Those do not meet your employer requirement. The employee is only required to have minimum essential coverage. So they can have, say somebody's unemployed or is a student and they just want to have coverage so that they satisfy the individual mandate. They can go in and get this minimum essential coverage plan that basically some of them don't cover hospital stays, or you can only go to the doctor twice a year. They'll have different ways to kind of keep costs down. So they will sell those, and some employers are buying that saying, well, at least it's something and it keeps the workers from getting in trouble on their taxes. The trouble is, if you are covered by the mandate, that doesn't get you out of your employer responsibility. You're still going to face that $2,000 penalty for not having offered the right coverage. And there's a definition called substantially all in the law. It just refers to covering 95 or offering coverage to 95% of your employees. For this year, they bumped it down to 70%, just to kind of get people used to the idea of offering coverage and kind of getting it in there. You can divide that up however you want, but generally speaking, you know what substantially all. I mean, if there are a few people that aren't offered it or don't get it, that's okay. You want to be careful to kind of say, I'm going to offer it to the healthy people, and this guy's always sick, so I don't want him to have coverage, so we'll offer it on the day that he's out sick, and then be careful of that. They're trying to put in rules for, they call it non-discrimination rules, and so they haven't told us what that is, what discrimination would be, but if you do it, it could be $100 a day per worker. So that will add up very quickly. So just something to, generally speaking, the safest rule is either offer to everybody or offer to nobody. You make your decision. But if you start saying, office workers, yes, field workers, no, or, men, yes, women, no, young people, yes, if you start kind of playing games with that, it could get expensive. Tax reporting. They have a brand new form. IRS is great at doing this. They can't necessarily explain it, but they have new forms where you'll be reporting beginning for this tax year, so it's going to be on next year's filings. Basically, what coverage is offered. You list all of your employees. There's a form that's sort of for the whole business, and then a form that's per worker, and it's going to say how many hours they worked in each month, were they offered coverage, did they accept it, what was the premium, et cetera, et cetera. A question that had come up before is, especially as an issue in agriculture, you may have workers that you've prepared a 9-9. As far as you know, they're here legally, but there's some percentage in the agricultural workforce that might be here on false documents, we'll say. Because you're reporting a social security number to the government, there's a natural concern of kind of what happens next. Are you going to get a letter in the mail that says, good job for offering healthcare coverage, by the way, you need to let go 2/3 of your workforce by Tuesday. Something like that. We've talked to IRS about this. There's a concern that this is kind of a backdoor e-verify, that basically you're just running all these people's social security numbers through a federal database, and that is never really a good idea. IRS has said, we only care about their money. Everybody's money is green. It's bad for business to look into this. It's not our job to enforce immigration. There's an agency down the street that does that. We really don't care. As long as it matches in our database to a name, Whether it's that person's name or not, we could really care less. So basically, you've been filing it with Social Security numbers for years. If they haven't caught up to it so far, there's nothing really about the healthcare filing that should change that. It should be okay. So, I mean, because they've always had databases, and there are some people that will get no match letters that, you know, there are two people filing returns on the same Social Security number, or that person's name doesn't match to the number that we have. Things like that, you'll get a letter, and you have an opportunity to have them check that. It could be a mistake. If there's two people, maybe one of them's correct, and as far as you know, your worker's the one that's done the right thing, and it could be somebody else that's done the wrong thing. So, you know, be careful. Don't be quick to let them go, but, you know, be responsive and kind of work with them on that. Forms that are filed, there's sort of two things, and kind of what triggers the penalties for the individual. It's that filing is going to let the government know that this person does have coverage because they've gotten it through their employer. They're fine. That meets their individual mandate part of it. If you file something that says they were not offered coverage, and then they will check their databases and kind of go through their supercomputer and figure out, okay, this person didn't get coverage to the exchange either. We don't think that they have coverage. So then that's going to trigger the penalty for the individual for the next year. To get the exchange subsidy, you know, if individual, you don't say you don't offer coverage at all, your workers go to the New York State website, they're eligible for a tax subsidy if their income is less than 400% of the federal poverty level. That's a lot of people. So they'll be eligible to get tax dollars off that. There's this King v. Burwell, they're actually going to be arguing that, I guess next week in the Supreme Court, or maybe the week after. That looks to whether, well, you have a state exchange, so it may not be an issue, that whether those tax subsidies are legally paid. There's a drafting error in the law. We can figure that out later, but the idea being that if one of your workers goes in, gets this subsidy, it generates a notice back to the employer saying one of your workers went on the exchange and got this subsidy. It's that notice that triggers the employer penalty. That's the $2,000 for not offering for all your workers. So if you have just one person that goes in and gets the subsidy, that's what triggers it. Theoretically, say you have 100 workers, you're going to be covered by this. You don't offer any coverage. It's not something that we're interested in doing, but none of them go in for whatever reason and go onto the exchange. Theoretically, you wouldn't have to owe a penalty, but that's running a huge risk that you're not going to have anybody go in. This is something that I know other people are going to be talking about later, but the deferred action for childhood arrivals, the DACA or DREAM Act kids, or deferred action for parents, they will get work authorization if that goes through. There's a district court decision in Texas that's blocking that right now, but assuming that that's reversed, this is the president's executive action from last November. These people will be work authorized for a period of time. They will be your employees. They will not be eligible for exchange subsidies because HHS says that they are not lawfully present in the U.S. They won't be deported right away, but for HHS purposes, they're not eligible for that. So just an extra little wrinkle of that. H-2A workers, however, are lawfully present in the United States under the statute. So there's been a lot of advice out there that you don't have to offer it to your H-2A workers. Don't worry about them. They're foreign workers. Not true. You do need to offer it to your H-2A workers. They are eligible for premiums on go to get exchange subsidies. The IRS treats them as employees. There was, until about 2011, you could pay them on a 1099. It was treated as non-wages. So they were considered independent contractors by the IRS. Since then, they treat them as employees. And since it's the IRS that decides whether you owe a penalty or not, it makes a difference what the IRS thinks about them. So basically, they're treated the same as U.S. workers. So again, at the beginning of the season, we're coming into planting time. You have new hires, new people show up. You want to send out that model notice, so that they know you do offer coverage, you don't offer coverage. They have that piece of paper. One of the changes in the law, and this is for large employers or small employers, there's a 90-day maximum waiting period. So assuming that you don't go through that kind of measurement stability period where you're not sure if they're going to be part-time or full-time, something like that. Basically, if you have a worker that comes in that's full-time, and if it's an H-2A, by definition, they're full-time because you have to be offering them full-time employment to get them into the country, you need to have them have an offer of coverage in hand within 90 days of their first day of work. Just to be safe, a lot of employers are just using the first day of the second month after hire because that's usually when signups would go from your health plan is on the first of the month. This way, So it could be as few as 2 months, but that way you're definitely going to be inside the 90-day period. For returning workers, this is a question of whether they can be subject to they work for a season, then they go away for the winter, either back to a foreign country or just to a different part of the U.S. for a while. Then they come back. Do they get the benefit of that 90-day period again when they come? IRS has determined that if there's a 13-week break, so basically about 4 months when you've not paid them at all, they haven't been on your payroll for 1 second out of that period, they're a new employee. So you start the process again, they can be subject to an additional 3 months. If it's less than that, you have guys that work basically 9 months or 10 months and then are gone for a couple months and come back. They're considered a returning worker. So you don't get to use the 90-day period. And again, on the measurement period, if it turns out that they were full-time last year, it's safest to say they're probably going to be full-time again this year. Issue, I don't know how many people use labor contractors or there's a company that supplies workers to other growers or other companies. We can go through this fairly quickly, that the burden on offering coverage is on the employer. Well, it's a question of kind of who's the employer, and this is a hot issue right now. There's this Browning-Ferris case where there's a labor supply company sent workers there. They tried to unionize, and they said, no, your employer is the staffing company, not us. You work here, you come here Monday through Friday, but your employer, you get your paycheck from the staffing company. And so the argument that the government is advancing is, no, you're both the employer, and so they can unionize either way. So there's a question of whether two people could theoretically have to offer coverage to the same worker. Somebody could have two employers at the same time. They haven't really sorted it out. It hasn't come up, but just something to keep an eye on if you're using labor contractor workers. We talked about dependents. Again, workers are free to opt out. Part of the wrinkle of dependents is if you have an H-2A worker, they may have kids, but they're not in this country. So you can offer them coverage, but what good does it do? You have your Empire Blue Cross card, then they try to take that into a doctor in a foreign country, and it's a garbage. So, at least offer it to them, understanding that they won't take it, if they're smart, because otherwise they're just giving you money for nothing. But realistically, it's just something to keep an eye on for that. And again, for H-2A workers not maintaining coverage, if they say no and they don't go on the exchange, and this is probably going to happen to a lot of these workers, they'll face a penalty in the next year. And there are a lot of people that don't file their tax returns. They're H-2A workers, they go home, they don't think to file it. A lot of people think that they don't have to pay taxes. That's not necessarily true, but the concern is, as Frank mentioned, that they get hung up on their consular visit the next year. They come back and say, well, did you pay your taxes last year? Did you have health insurance last year? They may start asking. Now all of a sudden the guy that's been working for you for 10 years doesn't make it back into the country, and you end up with a completely different workforce. So just another thing to keep an eye on. When making your decisions about, okay, I think we're a large employer, we have to decide kind of how we're going to handle this. And again, it's this affordability test that it comes down to, that, if the insurance company is charging you $400 per person and the worker can only pay $100 of it, now it's $300 per person per month. Or maybe they're offering it for $150 and the worker can pay $100. That really changes it. Your bottom line calculation is what matters. So for some people it makes sense to offer, some people it doesn't. Usually it makes sense to offer it because the tax penalties that you get hit with are so steep, and those are actually indexed to inflation, so it's going to start to go up in the next few years. Those are not tax deductible. It's treated as a penalty. You've done something wrong, so that money is just gone. Whereas the coverage subsidy, so that when you kick in the difference to get the person up to the premium cost, so get them from 100 to 150, you can write that off as a business expense. So for what it's worth, that goes into the calculation. That may end up making it a little bit more affordable than it originally looks. Keep an eye on control group issues. If you have, again, sort of a husband owns one company, a wife owns another, or they each own shares. They're combined for purposes of figuring out if you have 50 or 100 workers, but each of those companies can make their own choice. You have related companies, so maybe you want to offer coverage to your packing employees, but not your field employees or something like that, because they're in separate companies. That's something to look into. It may make sense to pay the penalty for some and not for others. And remember, the first 30, there's no penalty, so if you're kind of right on that cusp where it's the part-time people that are putting you over the top, it may be a better deal not to offer for one, but do offer for the other. If you're a very large employer, these are people with over 200 full-time employees, they're going to start having automatic enrollment rules soon. So that basically all of the employees will just get coverage by default unless they specifically opt out. Turning the page to tax issues. A lot of this is related because, again, the Health Care Act is enforced through the tax laws. So IRS is the main body that's enforcing this. For H-2A workers, and again, this is a lot of you, but not all, for years, they basically didn't have to pay taxes. Under the Bracero program, there was no income tax requirement, and that's what people got used to. So for 50 years or so, they just weren't required to. IRS, after they changed it to the H-2 program, theoretically, they were treated as U.S. employees, and they were supposed to have changed that. They just never really got around to it. So it was only recently that they started making employers report on a W-2. Now, basically, they follow most of the U.S. tax laws for H-2, but not all of it. IRS publication 519 is that's a good thing to go to. If you go to irs.gov and just search for publications, this will have most of the information you want. If you have more specific questions, that's a good starting point. That covers foreign workers or non-resident workers. Withholding is not required still. You do not have to do withholding for H-2A workers. However, they do have to pay taxes. So if you've not done the withholding, they're going to get a big surprise next April maybe when they file and they haven't put anything in. So, and again, as Frank mentioned, they could get hung up coming back into the country the next time around. So just sort of the best practice a lot of times is to, sit down with the employee when they start and say, just for your own protection so that you are covered and you're not going to get a huge tax bill next year. We probably should do withholding, but it has to be voluntary. You could have the employee say, I want you to do withholding, and the employer can say, I don't think I want to do that, or vice versa. But the employer says, I think it's in your best interest. If they say no, you can't do it. There's a sort of a footnote to that if they have not given you a Social Security number, there's a backup withholding of 28% that you do, just because IRS needs to have the Social Security number to process it. That's a separate issue, but generally speaking, it has to be voluntary. Most employers will do it. It's probably the best thing. It's going to protect them and you going forward. But for New York state law, they have even less guidance on this than the U.S. government. They talk a little bit about what they call non-resident workers. They recognize that there is such a thing as a foreign worker here on a visa, but don't really spend a lot of time talking about it. If you go on their website, you can look around, but there's not a lot there. Basically, the only guidance is that when your worker gets a Social Security number, you have to report them to Department of Tax and Finance, make sure that they sort of open a file for them, make sure that they're up and running. So, but that's really when you're first hiring. It's a good idea to have workers get a Social Security number. They can theoretically cross without one, get their visa, but it makes the process run a lot smoother if you take them into the office to get a number when they come. There are tax treaties with some countries, Mexico being one of them, that change some of the requirements. Again, if look for either search alien taxation or go to that publication 519. That will give you a lot of the information on this. Failure to file a return for the employer to report to the IRS exposes you to penalties. So, even if it's an H-2A worker, make sure that you're putting that information into the government. There's significant exposure there. Failure to provide them with the W-2 that they're now required to get, $50 per person. These things will add up. There's this idea of, and I realize this is incredibly small print on a big screen, whether they're a resident alien or a non-resident alien, they will file different returns and have slightly different rules as to their deductions. Basically, the test's 183 days. If they're in the U.S. for more than what works out half the year, they're going to be treated as a resident alien. So there's a different set of filings, and then during the 6 months of the year that they're in a foreign country, their foreign income is actually U.S. taxable, which makes it that much more complicated. There's a formula for if they're here for less than 183 in this year, but have been here for a series of years. A lot of this is sort of for the worker to have figured out. It doesn't really change a lot from your perspective, but they will have to file a different form. And I know a lot of employers will actually bring their workers to, say, an H&R Block or Jackson Hewitt, or, into a tax preparer and just sort of say, I have a bunch of people that are going to come in, they're foreign workers, get up to speed on this publication 519, kind of help them through their process. It's just going to make things run more smoothly in future years, that that your guys are paid up, they're going to come back through, cross the border, no trouble the next year. But a lot of these are things that they need to take care of and get right. Different rules here for resident, non-resident. There's even, to further complicate it, if they're dual status, let's say they start the year as a non-resident, but because they're here for 9 months, they've become a resident at the 6-month point. There are different rules for how you tax, how they're taxed for part of the year. And that's it.